Hi, everybody. We have a case today regarding lawyer approval conditions and how those conditions are relatively easy to enforce. And also, if somebody is relying on them, then the solicitor-client privilege remains intact. So let's jump into it. The case at hand is Yui versus Yan. It's a 2025 Court of Appeal case. And in this situation, there is an assignment agreement. So it's not a purchase agreement, but I'm sure the same principles would apply to a purchase agreement. So in this case, there's an assignment agreement and a $60,000 deposit, and there's a condition that the deal is subject to the approval of the assignee's lawyer within 17 banking days. And so what happened is that the assignees decided to rely on this condition and back out of the agreement. So their agent communicated to the assignor or assignor's agent that the assignees are backing out. However, that email or that message rubbed the assignors the wrong way, and they felt that perhaps there was an alternate reason because the agent was not clear that the assignees are relying on the condition. So the assignors felt that maybe there's some other reason, maybe it's not the solicitor. So that's partly what led to this litigation. And there's a lesson right there that the communication is very important because in this case, it raised some doubts or concerns in the assignors' minds, and they decided to take it to litigation. So the communication is very important. So whenever somebody's relying on these conditions, it's important to specify that they're backing out because of this condition and not because of potentially some other reason or just staying silent and just saying, hey, we're backing out. It's important to be specific and clear. We're backing out because we're relying on this solicitor condition. So litigation ensued. And what did the Court of Appeal find here? So the Court of Appeal found that because this condition was worded in such a way that it stated that it's based on the assignee's solicitor's own and absolute opinion. Again, own and absolute opinion. So because it was a very simple condition that did not specify that reasons have to be provided, the Court of Appeal found that, therefore, these reasons do not have to be provided. Solicitor-client privilege is not waived. The assignor is not entitled to the reasons. The reasons could have been any reason at all. They're not entitled to it. So that's an important lesson right there. Solicitor-client privilege is not waived. And if the assignors wanted those reasons, they should have put them in the condition that the reasons would be provided. Or perhaps that the condition is not on the solicitor's own and absolute opinion, but some kind of reasonable opinion, right? So the wording of the condition is very important, but if it's a very simple, straightforward condition that the deal is conditional on the solicitor's own and absolute opinion, then the assignors have no luck. No, their arguments have no merit. They're not entitled to the reasons. Solicitor-client privilege is not waived. So that's what happened in this case. The Court of Appeal decided that the assignors are not entitled to those reasons and that the condition is enforceable. And so basically, the assignors were able to get out of this agreement to rely on the condition and get their deposit. So again, these kind of conditions, when they're worded very simply in a very straightforward manner, they are easily enforceable and solicitor-client privilege is not waived. I hope you found this session useful. Thank you for watching, and I'll see you next time.